May it please the court, my name is Kruger, Kruger, initial K, and I appear for Plaintiff Lucy Luckless. I am instructed by Tommy Profit Lawyers. Your Honour, there are two matters before the court today. First one is the defendant Hugh Hackman engaged in misleading conduct under Section 18 of the Australian Consumer Law. My client seeks a remedy of deleting the entire contract clause from the written cash contract to allow enforcement of the oral vendor finance agreement. The second one is that Hackman cross-claims that if the vendor finance contract is found enforceable, that my client engaged in misleading conduct under Section 18 of the ACL, New South Wales, in providing the inept report. Your Honour, from the beginning of the contractual arrangement between my client and the defendant has engaged in misleading and deceptive conduct. The first time was convincing my client that the use of my client's real estate agent, Sam Slick, for the complete cash sale was irrelevant due to a personal vendetta, convincing her to save money and only use Slick to deal with the legalities of it all. Had Slick been aware of the cash sale, and the defendant would have had to sign a different agreement under the Clause 26, which would have made him accountable for the vendor finance of $900,000. This verbal agreement was made in the presence of a reliable witness who can confirm the details. We draw upon Fulban Catering Services Limited, incorporated in Papua New Guinea, and Compass Group Australia, Private Limited, 2008, Federal Court, Australia. The full court at 91 similarly observed that it is clear that to make a promise which is not performed or prediction which is not fulfilled is not without more misleading or deception. We rely on Men's Holdings Private Limited against Cemet Private Limited, number 2, 2011, Federal Court, Australia, 981, where the court added that it is only where the making of a promise or prediction contains an implied representation of the present fact, such as a representation that the promiser is capable of performing the promise, and the promise or prediction can be misleading or deceptive. Alternatively, if the promise can be construed as a representation with respect to future matter, the promiser does not have reasonable grounds for making the representation. It is taken to be misleading, and this is an excerpt from Trade Practices Act 1974, Section 51A of 1. In this case, the promiser, unless adduces evidence to the contrary, is deemed to not have had reasonable grounds for making a representation. Another excerpt from the TP Act, Section 51A 2. Acting on his deception, the defendant then avoided signing the statutory declaration, which my client had drawn up to ensure the defendant didn't claim the Clause 26 would supersede the previous oral agreement. We draw upon DI Enterprises Private Limited against Classified Transport Private Limited, 2011, Supreme Court of South Australia, 123, as well as 111, Supreme Court of South Australia, 155. The trial judge concluded that G. Carter had intentionally engaged in misleading and deceptive conduct right from the very beginning, allowing the respondent to recover damages and erred in finding that the oral collateral contract is enforceable. Therefore, my client seeks a remedy of deleting the entire contract clause from the written cash contract to allow enforcement of the oral vendor finance agreement. The defendant has cross-claimed that if the vendor finance contract is found enforceable, that my client engaged in misleading conduct in providing the inept report prior to any form of agreement made. We rely on Henville and Walker, 2001, High Court of Australia, 52, on the 6th of September 2001, page 55. The full court explained that Mr. Walker's misrepresentations were not merely an essential condition to which Mr. Hellenville's loss could be traced. Rather, Mr. Hellenville suffered loss because the full court noted he relied on the feasible study as well as Mr. Walker's misleading conduct. This case may seem disparate to the current case at hand, but it provides evidence that feasible study and deception lead to loss. However, the defendant in the case of my client chose to ignore the inept report, stating, "I wouldn't rely on your report as I've done my own analysis." Thus, the cross-claim of misleading conduct has no grounds due to the fact the report was never used to entice the defendant to make an offer. Your Honour, my client is seeking to enforce the vendor finance agreement and delete the entirety of Clause 26 in the contract. in order to be awarded damages of $900,000 and to dismiss the cross-claim of deception by the inept report that was not considered during the decision process that led to the vendor finance agreement. May it please the court.